The team, led by Senior Counsel Professor Gedu Muigai, will have 15 minutes to respond to the questions that were 30 minutes to respond to the questions that were raised yesterday.
Good morning, Madam Chief Justice and the distinguished judges of this court. We are ready to respond to the questions that the court put to us at the end of the day yesterday. I have Mr. Mahat Somane, who the court has already found a fairly useful man in explaining numbers, and he will be responding on the numbers. But I have brought on board Mr. George Murugu, who has previously not been on the front bench, who is very, very well acquainted with the architecture of the electoral process, and both of them will be responding in the 30 minutes that you've given us. But there was a question directed to me personally by Lady Justice Jokindong, and I will deal with that question at the very end. Mr. Broko.
Good morning to all of us again, and Senior Counsel, just before your team starts, on the question of voter turnout, and as you respond, please bear in mind the following so that we know that you are answering our concern. In Forms 34A, some of them have the rejected ballot. That's what Mahat taught us yesterday, added to the votes cast, so that the figures on 34A are not necessarily the figures in 34B and not in 34C. So tell us, as you answer the question in your own manner and style, on voter turnout, was it calculated on the numbers in 34A, B, or C? Senior Counsel, you understand our concern? Thank you very much.
Madam Chief Justice and President of the Supreme Court of Kenya, honorable and distinguished judges of this court, my name is George Murugu. I am here to answer questions that then the bench put to the Commission and to the Chairman. I will be as brief as possible, noting the little time that I have, and I hope that I'll be as useful to the bench as my colleague Mr. Mahat has been. Now, I will straight away start with the questions that were put to the first and second respondent by His Honorable Justice Ouko. And the first question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that a voter will be issued with ballot papers for all elections in a multiple election. That is at Regulation 69.2. At 69.2A, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But at Regulation 77E, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.3, the presiding officer then is put under an obligation to record in Form 41 the head of rejection for each ballot, and for our purposes, Subregulation 3D then addresses the question of unmarked ballots. Regulation 81B then provides that rejected ballots, such as the unmarked ballots, are sealed in a tamper-proof envelope and placed in the ballot box. That is how they are accounted for, Honorable Justice of the Supreme Court. The second question that I shall deal with, and this again it was posed by His Honorable Justice Mr. Ouko, was whether the appointment of the chairperson as the returning officer was as an agent of the commission or as a national returning officer in his capacity as chairman. This is how I would wish to address this question. It is a direct one, and the answer lies in the Constitution. Article 138(10) places an obligation upon the chairperson of the commission to declare the result. So the gazettement was not for purposes of Article 138(3)(c), but specifically for Article 138(10), to fulfill that role, to take up that responsibility, to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the Gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138(10) would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the Gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result. Beyond that, it is superfluous. And I urge Madam Chief Justice and Honorable Justices of the Supreme Court that that particular gazettement should not be read to mean that the chairperson had gone rogue, that the chairperson had taken upon himself and arrogated unto himself a power that he did not have. It is the Constitution speaking. It is in fulfillment of a constitutional expectation and obligation under Article 138(10). If you allow me, my colleague Mr. Mahat Somani will address the other punctuated questions that don't feature in my presentation. I will address the questions posed by His Honorable Justice Mr. Lenola, and this question is to do with the understanding of the state of the law as far as Section 83 of the Elections Act is concerned. And this is our submission, that the law is in a state of flux. Why do I say this? In 2017, the statutory provision that then existed suffered an amendment through Election Law Amendment Act number 34 of 2017, effectively repealing the 2017 provision. Now, the new amendment similarly suffered terminal fate before the High Court in the Katiba Institute case. Therefore, one would be tempted to argue that as far as Section 83 is concerned, we have no law. But in my humble opinion, I would be more kind to the state of the law as it exists. It's in flux. Why do I say this? This court had had opportunity to address questions of what happens to a repealed statute when the replacing statute itself suffers the same fate in the BBI case. And there was differing opinion, understandably so, because it's not a question that can be easily wrested. In my earlier days, if you ask me, I would say there's no power to animate the previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election beyond Section 83. That safety net is to be found in Articles 81 as read together with Article 86. And specifically for purposes of a presidential election, we must read it together with Article 138(3)(c), which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138(10). So that at Articles 138(3)(c), there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. All right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, sorry, 2, where counting is involved of votes cast, and Article 138(4), which then sets the criteria for declaration under Article 138(10). So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies? It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process, and were ready for announcement by Professor Goulier. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Goulier, filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions, and injuries to officials, including commissioners. In his mind, it was prudent to conclude the exercise since Article 138 3C had been fully satisfied. And there was a legitimate expectation that the results were to be declared on the 15th of August, as had been announced on that very morning. I'll quickly address the questions that were raised by Honorable Lady Justice Njoki. The term commission used in multiple senses. How do we know which sense is applied when? My quick response: it is a question of the context in which the term commission is used. Section 2.1 of the IEBC Act defines the commission to be the IEBC. Section 11A then breaks it down further to provide that there is that policy organ which is then constituted of the commissioners, including the chairperson, which then tasks itself with oversight, strategy, and policy, and the secretariat that then deals with administrative issues on a day-to-day and executing matters of policy that then the commission, or rather the membership of the policy organ directed. Therefore, in my humble submission, it's a question of context on how the term is used. What are the checks for this all-powerful chair? For instance, if he was to announce the wrong results or be incapacitated in such a manner that then he could not declare the result. The checks are to be found within the constitutional and statutory framework. Follows. Article 138 then speaks to the checks. Article 138 3C speaks to a verification and tallying process that then engages the commission, the body corporate, so that there is no room for the chair to act as a lone ranger. And while I'm at this point, it is important to point out that in this particular case, Article 138 3C was fully satisfied. My lady, my lords, a narrative has been created that certain commissioners were given roles akin to domestic services. Nothing can be further from the truth. We all saw it. We all saw the commissioners interacting with the results, interacting with the verification and tallying process. We all saw them announcing these results. We cannot unsee what we saw. But then, just to lay emphasis on this, I would wish to quickly refer the Honorable Court to paragraphs 40 of the Chairperson's affidavit, Wafula Chebukati, paragraphs 8 and 9 of the affidavits of Professor Abdi Gulier, and paragraph 7 of Boya Molu, we speak to the truth of this issue. Quickly, my lords, on the last question, on the issue of agents and their roles. Agents play an important role in the electoral process. It's up to the parties and candidates to appoint them. But for purposes of Regulation 79(7) and 62(3), the absence of agents does not invalidate proceedings at the polling station. That would be the end of my presentation. Unless the court has any question for me, I would ask to resume my seat. Thank you, and invite Mr. Ma.
My Ladyship, CJ, Chief Justice of the Republic of Kenya, My Ladyship, the Deputy Chief Justice and Associate Justice of Supreme Court. I will try to waltz and do very fast because I'm short for time. I will mention the judge who asked the question and I will give my answer precisely. Justice Ouko asked the question that 33,000 votes, there's a variance of 33,000 votes between governor and president. Nothing could be further from the truth. The variance between the presidential and the governor is 24,000 votes. The same can be accounted for stray ballots. He asked the question, what are the stray ballots all over the country? We have to look at all those ballot boxes to get what are the exact stray ballots in those. But I did a bit of analysis, and I've attached the analysis in Kibra and in Makadara. It is 2 per polling station. And the beauty about this is late last night, I also ran an analysis on the scrutiny report that we were given for the 18 polling stations, the report of the registrar. It exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations, even if you looked at the scrutiny report. That gives you a figure of 92,000, the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and if that could run, the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballot. So to the question that someone can vote for one candidate and leave the others, it's not true. It's actually, the regulations don't allow. It's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence, 229. I think the number you are interested is how many people voted manually, 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kits, right? The second question just also said, Omtata says 1,665,412 people curiously voted when the polls closed at 9. I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it, it sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah? So that is how the number changes. The polling will close, but some kins will be sending the people, how many people went through. And it's only when we know, when all the kins have transmitted, and we know how many people have voted manually, that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commences on 6 a.m. on the next day. Some places in Eldas, KIMS reported happens once the network, once it has network, and it requests to connect. So I think it's a false analysis because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMS will keep on giving that information. Just Eleonora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training Form 34A. I have also given the password. The courts can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper. It will ask you for the gray scaling, and you will see how we do it. And we do for JPEG because all your phones take JPEG. We want to differentiate our image from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start from. The reason why we give turnout is a measure of transparency and integrity to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the KIMS 589,961. On 10th August is 21,926,565. If you deduct those numbers and you compare to the people who are actually identified by the kits, actually the people who are identified by the kits is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reached 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified under the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMs have reported. So when all the KIMs had reported, because this is a snapshot of that information in time, when all the KIMs had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that policy we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deployment of infrastructure and the servers platform. They did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact, the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there's no agent, Justice Muilu asked, if there's no agent, what happens? The integrity, the processes that we have in terms of the KIM's return, in terms of the portal, even if there's no agent, we can actually confirm what happened. So it's not the role of even if someone said, I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have, go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that. If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate, 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the IEBC logo in the background, both images, same. If you look at the exact paper fold in the bottom left corner of both images, same. The image is brightened to show that it has undergone editing. That's the top left is dark. The agent copy is in JPEG. The form is uploaded on our form is uploaded on the portal 10th of August 2022 at 2 days later. And we have put that in our affidavit, actually. You can check all the edits.
Sorry, Council, you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave two examples. If you can just go back, I think I'll start with the first one. The 185, yeah. If you can go back.
We'll give you 5 minutes, see what you can do with it.
Yes, yeah. Thank you so much, Madam CJ. So what we did is we just took the form they provided us, and we juxtaposed as against what we have. And we've marked all the places what is wrong with that form. And what is wrong with that form? If you look at the QR code, up on the left, on the right, and also on the left, the QR code, it's cropped similarly in both pictures. The IEBC logo underneath the document coincides with what was the pressing officer. It's actually an impossibility. I've given you a form to take a picture, and what you are producing me is actually underneath the logo of the document, the IEBC logo that the presiding officer was using. So I've given you your form, you're taking your picture for your agent, and you're using the same that the IEBC PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact, you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's no any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera. And I have noted all the things that are wrong. The exact